Hi, everybody. This is David O'Dea with O'Dea Schneider PLLC, and today we're talking about Brady evidence, one of the most important concepts in criminal law and a cornerstone of fairness in our system. The term Brady evidence comes from the Supreme Court's decision in Brady v. Maryland in 1963. In that case, the court held when the prosecution suppresses evidence favorable to the accused, it violates due process if that evidence is material to guilt or punishment. The principle is simple but powerful. The government cannot hide evidence that could help the defense. So, what does Brady evidence include? It includes any information that's favorable to the defendant. That means evidence that tends to show innocence or reduce culpability. And it also includes evidence that can be used to impeach the credibility of a prosecution witness. For example, if there's a lab report that excludes the defendant as the source of DNA, that's Brady material. If there's a statement pointing to another suspect, that's Brady material. And if a key witness has a prior inconsistent statement or has been promised leniency in exchange for testimony, that too must be disclosed. The Supreme Court made this clear in Giglio versus United States, which extended Brady to cover impeachment evidence because credibility can make or break a case. Now, that duty to disclose is not optional, it's an affirmative constitutional obligation. Prosecutors must turn over Brady evidence whether or not the defense asks for it. The court reinforced this in United States versus Bagley, rejecting the idea that disclosure depends on a defense request. And this duty applies to the entire prosecution team, including law enforcement. It doesn't matter whether the suppression is intentional or accidental. If the evidence is material and favorable, withholding it violates due process. Now, not every favorable piece of evidence triggers a Brady violation. The standard's materiality. Courts ask whether there's a reasonable probability that had the evidence been disclosed, the result of the proceeding would have been different. A reasonable probability means enough to undermine the confidence in the verdict, and the courts look at the cumulative effect of all the withheld evidence, as the Supreme Court explained in Kiles v. Whitley. Even if individual items seem minor, together they may be significant. Now, when a Brady violation occurs, the consequences can be serious. Before trial, a judge may order disclosure, grant continuance, or exclude evidence. After conviction, the usual remedy is to overturn the conviction or vacate the sentence. In cases of intentional misconduct, prosecutors can face disciplinary actions or even sanctions, but the real cost is borne by the defendants and by the integrity of the justice system. Ultimately, Brady violations are unfortunately not rare. They happen for many reasons. Sometimes prosecutors fail to recognize the impeachment evidence counts as Brady material. Sometimes police reports or lab results are overlooked. And in today's world of digital discovery, the challenge can be even greater. Prosecutors may have to sift through terabytes of emails, text, and body cam footage to find a favorable evidence. And that complexity increases the risk of mistakes. Despite decades of precedent, studies show Brady violations remain widespread. Hundreds of wrongful convictions have involved suppressed evidence. In capital cases, nearly half of Brady violations involve both exculpatory and impeachment evidence. And as technology expands, compliance becomes harder, not easier. Brady is more than a procedural rule, ultimately. It's a safeguard against wrongful convictions. And when prosecutors withhold evidence, the integrity of the system suffers. Public confidence erodes, and innocent people pay the price. Full compliance with Brady obligations are essential to upholding the principles that justice seeks truth, not just convictions. Thanks for watching the video.